stop. Before you close this tab, before you go back to scrolling, if you are on an H-1B visa, if you are waiting for an H-1B lottery result, or if you employ H-1B workers, what I am about to tell you in the next 15 minutes could literally change your future in the United States. Welcome back to Immigration Law Station, the channel where we cut through the legal jargon and give you real, actionable immigration information fast. I'm your host, Alex, and today we are diving deep into the sweeping H-1B visa rule changes that took effect and continue to roll out through 2025, changes that affect hundreds of thousands of workers, families, and employers right now. If you are new here, hit that subscribe button and tap the bell icon, because in the world of immigration, being even 1 week behind on information can cost you your status, your job, or your place in this country. And before we go any further, important disclaimer: everything on this channel, including today's video, is for informational and educational purposes only. This is not legal advice. Please consult a licensed immigration attorney for guidance specific to your situation. All right, let's get into it. To understand what's changing, we first need to understand why this is all happening, because nothing in immigration policy changes without a reason, and those reasons directly tell us where things are headed next. The H-1B visa program has been under intense scrutiny for years. Critics, from labor groups to members of Congress on both sides of the aisle, have argued that the program was being exploited, that certain employers, particularly staffing companies and outsourcing firms, were gaming the lottery system by submitting massive numbers of registrations to artificially inflate their chances of selection. In fiscal year 2024 alone, USCIS received nearly 780,000 registrations for just 85,000 available H-1B slots. That is roughly a 1 in 9 chance for a single registration. But companies submitting dozens or hundreds of registrations per beneficiary were bending those odds unfairly, so USCIS stepped in, and beginning with the fiscal year 2025 H-1B lottery, which ran in early 2024, they implemented a beneficiary-centric selection model. What does that mean? Instead of each registration having its own lottery chance, the system now selects unique individuals first, meaning it doesn't matter if your employer submitted 1 petition or 50, you as the person only get counted once. That was just the beginning. In January 2025, USCIS published and finalized a massive new H-1B rule, officially titled the H-1B Modernization Final Rule, which overhauled multiple aspects of the program simultaneously. This rule was years in the making and is one of the most significant updates to the H-1B program in over 2 decades. The drivers behind this? 3 things: fighting fraud, improving program integrity, and expanding protections for workers. Those 3 goals sound simple, but the devil, as always, is in the details. And those details are what we are breaking down today. For decades, the term specialty occupation, which is the legal standard a job must meet to qualify for H-1B, was interpreted somewhat narrowly and inconsistently. Under the new rule, USCIS has clarified that a position qualifies as a specialty occupation if it normally requires a bachelor's degree or higher in a specific field. But the degree doesn't have to be in a single, exact major. What this means practically: if your job description is broad, say business analyst or IT consultant, USCIS will now look more carefully at whether the actual duties of the position require specialized knowledge. Vague job descriptions are now a red flag. Employers must submit detailed, specific job duty lists with petitions. This change comes directly from the USCIS H-1B Modernization Final Rule, effective January 17, 2025. If you work through a staffing agency or consulting firm and are placed at a client's office, listen up. This is one of the most impactful changes for the IT consulting world. Previously, employers could petition for H-1B workers placed at third-party work sites with relatively general documentation. Under the new rule, USCIS now requires specific, concrete evidence that the work at the third-party site meets specialty occupation requirements. This means actual contracts, statements of work, and letters from the end client confirming the nature and duration of the work. If that documentation is missing or vague, expect a request for evidence or outright denial. For the entire staffing and IT consulting industry, this is a game changer. Good news for some. Universities, nonprofit research organizations, and government research entities are CAP exempt, meaning their employees don't go through the annual lottery. Under the new rule, USCIS has expanded and clarified who qualifies for CAP exemption, making it somewhat easier for workers at qualifying institutions to access H-1B status outside the lottery. This is a real opportunity for workers who are frustrated by repeated lottery losses. If your skills are transferable to a university research role or a qualifying nonprofit, that path now has clearer, more accessible guidelines. The new rule also provides clarity on when employers must file an H-1B amendment, which is a formal update to your petition when your job duties or worksite changes significantly. Many employers previously guessed at this threshold. USCIS has now made clear, material changes to job duties or location require an amendment before the change happens, not after. Failing to file a timely amendment can jeopardize your legal status entirely. This has always been the rule, but the new guidelines make enforcement expectations unmistakably clear. This is a big one that doesn't get enough attention. The new rule includes explicit anti-retaliation provisions protecting H-1B workers who assert their legal rights. For example, complaining about wage theft, unsafe conditions, or violations of the labor condition application terms. Previously, H-1B workers were often afraid to report employer violations because they feared losing their job and, with it, their visa status. The new rule signals that USCIS takes these protections seriously and that employers who retaliate can face consequences including loss of H-1B petition privileges. For F1 OPT students transitioning to H-1B status, the CAP gap period, the time between the end of your OPT authorization and October 1st when H-1B status begins, has been clarified and in some cases extended under the new rule. Specifically, USCIS has clarified how CAP gap applies when there are delays or complications in employer petitions, giving students more breathing room and predictability. This is crucial for thousands of international students graduating every year and counting on that bridge period. Now let's talk about who these changes hit hardest, and I want to walk through some hypothetical scenarios so you can see yourself in these situations. These stories are for illustrative purposes only and represent composite, anonymized examples. Let's call our first person Priya. She works for a mid-size IT staffing firm and has been placed at a Fortune 500 company's headquarters for 2 years. Her employer is filing her H-1B extension petition. Under the old rules, a general contract and job description might have been enough. Under the new rules, Priya's employer must now provide the actual statement of work from the client, a detailed job duties description, and confirmation that the role genuinely requires a specialized degree. If Priya's employer doesn't gather these documents in time, or if the client company is reluctant to share proprietary contract details, her petition faces a serious risk of an RFE or denial. Again, this is a hypothetical example for illustration purposes only. Now let's look at Marcus. Marcus graduated with a computer science degree last May. His employer filed an H-1B petition in the April lottery, and he was selected. But there were delays in USCIS processing. Under the updated CAP gap clarifications, Marcus can continue working on his OPT extension through the CAP gap period while his H-1B is pending, as long as his employer filed on time and his status remains valid. This clarity saves Marcus from an employment gap that would have put both him and his employer in a difficult position. Again, hypothetical example for illustration only. And finally, think about a staffing company that places 50 or more H-1B workers at various client sites. Their previous process, sending generic offer letters and broad job descriptions, no longer meets the new evidentiary standards. They now need individualized documentation packets for each worker, with client-specific information. Companies that don't update their internal HR and legal processes quickly will see a wave of RFEs and denials starting now. The bottom line? If you are an IT professional in consulting, a recent graduate on OPT, a small business owner sponsoring H-1B workers, or an HR manager at a staffing company. These changes are not abstract. They are happening to real petitions being filed right now. Drop a comment below. Which of these situations matches yours? Let us know, and we'll try to address your specific scenario in a future video. All right, this is the section that can save your immigration case. These are the most common and costly mistakes people are making right now under the new rules. Write these down. Mistake number 1, waiting until the last minute to gather documentation. Given how much more documentation is now required, especially for third-party placements, employers and attorneys who wait until 2 weeks before filing to gather documents are setting themselves up for failure. Client companies can take weeks to produce statements of work. Start the documentation process at least 60 to 90 days before your intended filing date. Mistake number 2, assuming your old petition strategy still works. Just because your H-1B was approved 3 years ago using the same job description doesn't mean USCIS will approve it again today. The adjudication standards have changed. What passed before may not pass now. Every new petition and extension must be prepared fresh with current evidentiary standards in mind. Mistake number 3, ignoring amendment requirements after a job change. If your job duties have materially changed, or if you have moved to a significantly different work location and no amendment was filed, you could be considered out of status. This is a violation that can haunt you at extension time or during green card processing. Don't assume small changes don't matter. Consult your attorney. Mistake number 4, not knowing your rights as a worker. Too many H-1B workers are afraid to speak up about wage theft, improper deductions, or unsafe conditions because they fear deportation. Under the new protections, retaliating against you for asserting your rights is explicitly prohibited. You can file complaints with the Department of Labor's Wage and Hour Division, confidentially. The website is dol.gov/agencies/WHD. Mistake number 5, using unverified information from social media. This one is personal to me. We see it every single day. Workers making major immigration decisions based on a Reddit thread, a TikTok video, or a WhatsApp message. The consequences can be catastrophic. Always verify immigration news through USCIS.gov, the Federal Register, or a licensed attorney. Okay, enough warnings. Let's talk about what you can actually do. Here are your action steps starting today. Tip number 1, review your current H-1B petition immediately. Pull out your approval notice, your LCA, and your job description. Compare your actual current duties to what's on file. If there is a mismatch, contact your immigration attorney right away. Better to file an amendment proactively than to get caught during an extension or RFE. Tip number 2, ask your employer for documentation now. If you are placed at a third-party site, ask your HR team whether they have current statements of work and client confirmation letters on file. If they don't, that's a conversation you need to have immediately before your next extension filing. Tip number 3, read the H-1B Modernization Final Rule Summary. USCIS has published a plain language summary of the H-1B Modernization Final Rule on their website at uscis.gov. Search H-1B Modernization Final Rule. We'll also link it in the description below. Reading even the summary will give you a foundational understanding of your rights and obligations. Tip number 4, consult a qualified immigration attorney. We know attorneys cost money, but an RFE response, a denial appeal, or, worst case, a status violation costs far more. Use resources like the American Immigration Lawyers Association directory at aila.org to find a qualified H-1B attorney in your area or one who works remotely. Tip number 5, set up USCIS case status alerts. You can sign up for automatic case status email alerts at uscis.gov. This ensures you are notified the moment there is any movement on your case, including RFE notices, so you can respond quickly within the required time frame. And one more time, this video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney before making any decisions about your case. All right, let's bring it home. Today we covered the 6 most critical changes from the 2025 H-1B Modernization Final Rule. From the redefined specialty occupation standard to tightened third-party worksite documentation, expanded cap-exempt options, amendment requirements, new worker protections, and clarified cap-gap rules. These aren't coming someday. These changes are in effect now, and every H-1B petition filed today is being judged under these new standards. The most important thing you can do is get informed, get organized, and get qualified legal help. Do not navigate this alone and do not rely on unofficial sources. If this video helped you even a little bit, please give it a thumbs up. It takes 2 seconds, and it helps this channel reach more people who need this information. Share this video with anyone you know on an H-1B, anyone who works in HR or immigration compliance, or any international student heading into their OPT to H-1B transition. Drop your questions in the comments. What's your biggest concern about the new H-1B rules? We read every single comment. And join our Immigration Law Station WhatsApp community. Link is in the description, where we share breaking immigration news daily. Always verify everything through USCIS.gov and speak to a licensed attorney. Stay informed, stay legal, and we'll see you in the next video.